My name is Matthew Maddox. I'd like to speak to you today about marijuana laws in Connecticut. There is a common misconception in Connecticut that marijuana is legal. It's not. 5 years ago, July 2011, marijuana became an infraction if you were charged with possessing marijuana of less than a half ounce. You get an infraction, you get a ticket, the same way you might get a speeding ticket. You get a summons, you can respond by mail, either a not guilty plea, which would assign you a court date, or a guilty plea and you pay the fine. The further misconception that in connection with that infraction is that you send the guilty plea in and nothing else happens. It's all good, there are no further consequences. And that's a concern for us in our office. When you plead guilty to the marijuana infraction, there's a record. It's traceable for probably at least 2 years. So be careful about that. Once you are past the infraction level of marijuana, you're talking about a misdemeanor possession of marijuana under certain circumstances. Evidence gets seized by police and can be demonstrated or can be used as evidence of possession with intent to sell. Then you're in a felony area. The point about all the marijuana laws in Connecticut and the point about our perspectives and our ideas about marijuana is you have to be really, really careful. Marijuana is not legal in Connecticut, and you have to be careful whether it's an infraction or whether it's something more than that to be sure that you meet with a competent and experienced trial lawyer. This is what we do here. This is what our office does for people. We represent and protect people who are charged with offenses such as marijuana offenses. We lead you, we guide you, we protect you, and we defend you. And we make sure that before you make those decisions and commit, that you are doing those things intelligently and really understanding all of the consequences involved.